I'm Steve Sussman, the Executive Director of the Civil Jury Project. Welcome to El Paso's first Jury Improvement Lunch. It's the nation's 35th. We have held these lunches across the country. All of them have been videotaped, as is this one. And you can go to our website, the Civil Jury Project's website, and see this program. Show it to your colleagues. And you can see any of the other 34 if you're interested. In any event, I want to thank Judge Martinez for hosting us here in the federal courthouse. We had asked everyone to RSVP, so we'd have plenty of food. People have showed, we haven't turned them away, but it turns out we don't have food. The disadvantage, that's a disadvantage of doing in the courthouse. The advantage is that it costs us each $10 for lunch, whereas in other cities we have to go to hotels for $50 for lunch. So the next time you come, we will have more food available for you. And we hope that when you leave today, you will receive from us a questionnaire, one of these monkey surveys about whether you think this should be repeated, and if so, how often, what should be covered, and we are also looking for volunteers to help organize the next program. And a number of the lunches, which are on our list of the 34 that we've already had, have been repeats because several cities have. Dallas has had about 5, Houston has had 5, Seattle 2. So we're going back and doing these lunches at cities largely by popular demand of local law. I want to thank our host firms that are up there in our sponsoring organization who agreed to, in the main reason they agreed to get out the word to their members about this. We do not have your email addresses. So let me tell you, and we are going to try to, we're a little bit late with our program today, but we will try to finish about 1:30. Judge Martinez said he could run a little over, so I have his lead, but we'd like to try to quit probably at 1:30 so the judges can go back to their trials. Let me tell you a little bit about the Civil Jury Project and how it got going. I began practice, I went to the University of Texas Law School. I spent my entire career practicing law. Unfortunately, it's over 50 years now. In Houston, and when I began practicing in the late 60s and through the 70s, Texas was the epicenter of the trial bar in this country. Any list of the best 10 trial lawyers in America included at least 5 or 6 Texans. And those of us who were active in the late 60s and the 70s know it used to be great, and El Paso used to be a great place to file a lawsuit. Probably still is, in spite of efforts to control venue, to steer lawsuits in places where are not so hospitable to litigation. In any event, I was able to create a law firm that had 160 lawyers. Fully do litigation, commercial litigation, both plaintiffs and defendants, half and half now. And I was thinking, well, all these trials are disappearing. Young lawyers come to us who finish these prestigious clerkships for federal judges, and they complain, you promised you'd give us trial experience. How about it? When are you going to stop lying to us? And actually, one of them said that on a questionnaire we gave to people who we did hire. And the answer is, not until we convince the public. First, we have to convince the public that jury trials, indeed all trials, are disappearing. One of the first things we did as a Civil Jury Project, we conducted a survey of non-lawyers across the country and asked them the question, do you think the number of trials has gone up or down or stayed about the same? 80% of people said they've gone up. Contrary to every statistic in every jurisdiction in this country, state and federal, there's this disconnect between what the public thinks. The public thinks that this courthouse is as busy as it can be, and you can go out in the hall and shoot a cannon through the hall most days of the week and you wouldn't hit anyone. It's just like other courthouses all over the country, unfortunately. And there's variation, and I'm generalizing, obviously. But one of the things we decided to do was set up this academic center, the only one in the country that studies jury trial. We began by civil trials because I'm not a criminal lawyer, and I don't know about them. They are declining the same as civil trials, but for slightly different reasons. In any event, we set this up as the only academic center that was asking the question, why are trials disappearing? And when I say trials are disappearing, I'm going to show you some statistics in a minute. It's not just jury trial. It's not just civil and criminal. It's bench trials. They are going down and away quicker than jury trials. All the statistics show that. Fewer bench trials than jury trials. Quicker decline. So why is this happening? Do we care? And if so, what can be done about it? Do we care? So why it's happening? You can come up with a lot of different answers, and I put on your table a sheet of paper. I tried to do that once, and there are about 18 reasons I have been able to come up with. Take this sheet of paper with you. I characterize those reasons as things we can do something about. We, meaning the judges, state and federal, and the lawyers sitting in this room can do something about. And on the left side are reasons that Congress or the Supreme Court, someone at a higher pay grade than we have to work on the problem. So we listed this way, and you may suggest to me others. Please send us an email if you can think of other reasons, or send us an email if you think we have misclassified the reasons on this list, because we have determined to work on the things on the right side of the page, which are the things that can be done without changing the law. The law allows you to do everything on the right side of the page now. We don't have to have some change of the Federal Arbitration Act, but we don't have to have a change in the Supreme Court's summary judgment trilogy, the Celotex trilogy in the mid-90s, which caused a huge drop in jury trial, all trials in federal court. There are things that we can do something about, and that's what we have focused on in the Civil Jury Project. As to whether we should care, my approach to this is to say, well, the right to trial by jury is the only right that gets mentioned 5 times in our founding documents. It's in the Declaration of Independence, it's mentioned in the Constitution, and it's guaranteed by 3 of the Bill of Rights. Our founding fathers thought that no one should be deprived of their money in a civil case, or their property, or their freedom in a criminal case, without the approval of 12 citizens, tried and true, drawn at random from the community. They thought it was, the reason it's stated on the first, right in the Declaration of Independence, the king has denied us the right to trial by jury. They knew that judges who are appointed by a king, or for that matter, a president, can sometimes have to be loyal to who appoints them. They also knew that the judges that were elected, and a lot of judges were elected when the Constitution was passed. They belonged to the states. The judges who were elected could be influenced by those who they viewed as having the ability to influence their getting elected. So the idea was that you cannot mess with the jury. You don't know who they're going to be. You have they come there once in their life, the jurors, and then they don't come back unless they want to come. As these people have to teach us something, which is a wonderful thing. and they've gone well beyond the call of duty to be here today to tell you about this. But so, for all those reasons, I mean, I think before we get rid of jury trials, we should think about whether we can do things to preserve it. It was very apparent to us that the red line is the decline in jury trials. As a jury trial for average federal judge, the blue line is a decline in bench trials. And you can see from these figures that the number of jury trials has dropped from 10 civil jury trials, these are civil, has dropped from 10 per federal judge in 1962, and now is down at 2 per average federal judge. And the Western District of Texas, there were 22 jury trials held here, civil jury trials, and the criminal figures parallel this, I think, although we looked mainly at the civil figures. 22 jury trials held during 2018, getting 1.7 authorized judge, federal judge, 11 bench trials. Of the judges here in the Western District, each would trial less than a bench trial in 2018. And it puts the Western District of Texas right at about 50th for the district court with the most jury trials per judge, and 41st in the country for the number of bench trials per judge. When you look at the Eastern District of Texas, slightly more, 2.3 per authorized judgeship of jury trials, but still only 36. Comes in 36 in the country. The Northern District of Texas comes in 44th. The Southern District of Texas is doing the best at almost 3 jury trials per authorized judge and is in 20th in the country. But this is not the Texas that I knew when I began practicing. It was not the Texas in the 70s or even the early 80s. This is new for this state. But it's still in our blood. It is still in the water. And that's why you came, because you're interested in the subject of trials, how we can make them better, how we can warm them, and how we can get trial judges to be real trial judges. And if you look at this is, some can say, well, the number of trials is immaterial. It's the percentage of cases that get disposed of by jury trial. So we did this chart to show the same period of time. You can see that today, less than 1%, a half of 1%, of all civil cases across the country gets disposed of by a jury trial. And a smaller amount are bench trials. So, and that should be affected by the number of cases that are filed. It's the way we are disposing of cases. And the state situation, it's harder to get the figures for the state courts. I have not been able to get them district by district in the state courts. These are statewide figures. But if you'll see there, percentage of Texas state court civil cases resolved by jury trial is down. So one of the things we did is, when we began seeing these figures, the first thing we did was we learned out of the country, and we tried to get judges to become judicial advisors. We have now over 300 judges across the country who advise me for the civil jury project. And each of the judges who are here today, and I will introduce them in a second, I urge you to join us. It doesn't, all we need is your email address. And we will not bother you with anything but sending you a copy of our monthly email, our monthly newsletter. For 24 months now, we put out a monthly newsletter on developments in jury trials. And we would, of course, we sent you, because you came today, you lawyers, we have your email addresses. You will get these. But as I said, it's important to us to get the judges to come to and get involved. And this list on our website, the 300 judges across the country, state and federal, who have joined us as advisors with a disclaimer. They do not support anything we say. They just allow us to communicate with them by email. And we have, one of the things we have done with those judges, in addition to getting involved in events like this, we have put on programs at their judicial conferences around the country, their bench bar conferences, and most importantly, we have now had over 200 state and federal judges at our expense come to New York for a full day's workshop on how to try a jury case. That we have learned is a subject that is not even touched on at the new judges school for federal judges. They don't even talk about trying jury cases. I think a lot of state judicial education is better and you learn more. But just think, what chances do we have of preserving jury trials that the people who are being pointed to the trial bench in the federal system, and alas, this is happening a lot across the country now, have never heard, they've never seen a jury trial. They've never participated. I mean, maybe in the movie they've seen it, but they're not trial lawyers. And what is their attitude going to be about granting summary judgment or deciding a case on some motion to dismiss when it's a close case, and they do not want to go out and engage in an exercise that they have never been taught how to handle? They don't want to try. They don't want to try. They don't want to embarrass themselves. So you can figure out what's going to happen to our lawsuits unless we get the judges on our side. And that's what we've been working on for 4 years, to try to get the judges engaged in to try to tell them, you can't call yourself a trial judge unless you do better than 2 cases or 3 cases a year. And you need help. We need to help you figure out what's going on. You need to help us figure out what's going on. But these workshops are divided into 4 sections. We have 30 judges at a time. We have state judges and federal judges come separately. The first session is on jury selection. How do you go about selecting juries? And frankly, one of the effects we have had in the last 4 years, and it's demonstrable, is federal courts, which kicked us out of the voir dire process entirely because, I'll talk about Judge Mayo, that you win a case during voir dire, right? That's when you win. So you argue the hell out of your case. And the federal judges got upset with that. They said no more. They said, oh, ask the question. And for a while, it was uniform throughout this country that federal judges were doing all the voir dire. I would say now, since our project's been working and going around talking about this, that 50% of the federal judges in this country have let the lawyers back in the tent. They're going to kick us out again unless the lawyers are taught how to conduct properly a voir dire which seeks real information for jurors and not, argues the case. But that's a demonstrable change we have made. The innovation that we've gone around preaching a lot about, so that's how do you select the jury? How do you make it go faster? How can we make it simpler? And how, very important, how do we teach young lawyers to conduct voir dire? When was the last CLE course you have seen in Texas or anywhere on the subject of how to conduct voir dire? I have never seen them. It's hard to do, and they aren't done. If a lawyers don't know how to do it, the lawyer's not going to object when the judge says, I'd rather do this. You do it, which is what's going on a lot. The second part of our thing is care and feeding of the judges. We spend an hour and a half on that, of jurors, care and feeding of jurors. Can we make the hours better for them? Can we provide them better accommodations? Can we, for example, give them clearer instructions earlier on in the case? And will we allow them to ask questions? The jurors' ability to question witnesses, they submit it right in the world, is an innovation that is spreading like wildfire. I would say, and now the federal judges, about half of them are allowing it to happen. And in state courts, it's even higher. There are states that have rules that mandate the jurors be allowed to submit questions in writing through the judge to a witness if the juror doesn't understand something about the testimony. There are small steps we are taking, but they are steps. Another thing we do is have a website. This is not for the other websites for judges and law professors. We have 60 academic advisors on the project. Law professors, lawyers, law school professors, lawyers, judges. This is a website for people who are surfing the web. The idea came up when we went to the website and searched Facebook and Twitter and all the social media sites. We found jury comes up a lot of times, but it's mainly people looking for how they get out of jury duty. So the idea we came up with is, can we improve the response to jury summons? And you know that in some places in the country, less than 15% of people who receive a summons actually show up. And within the last 3 weeks, a judge in Florida put someone who did not show up in jail, or said he was going to put someone in jail for a week, and put him on probation for a year. And there was outrage about that. And he changed his mind, the judge changed his mind. But it shows the problem. So the idea is, can we get people to come here to this website, wethepeoplewethejury.com, and if they go receive a jury summons, what they do when they get there is they say, don't go away. Someone will tell them, someone will, like one of these jurors will tell them, don't go away your summons. You are about, if you get chosen, you are about to have the best experience of your lifetime. And then we have snippets of video testimony. The video testimonials from people who serve like you, who will say, I was on jury, I loved it, it was a great experience, and any of the ones jurors are here today, either on the panel or in the audience, are willing to give us a testimony, let us know, and our research fellow, Michael Pressman, who you met coming in, will use our videographer at the end of the program to take 3 minutes of your time getting you on a video where you will be talking. We have a lot of these videos from around the country that people see when they hit that, receive a jury summons. We have not yet determined whether this has increased the yield from the jury summons or not, but it might. How else are we going to get to these people? In the middle, if you go to the middle, and people have come to the middle, it says you should not be here. The judge told you are not to go to bed while you're serving on the jury. Wait until the trial's over and come back. And if you go on the right, which is you have served, completed your jury service, been discharged, then you have a questionnaire that you were asked to answer. We've had thousands of answers to questionnaires, which we have read from around the country and summarized, much like it's like written questions I'm going to be asking you all orally today. So if you don't get to say today what you really think, it's not too late to go to the site and tell it the way it is. You might have to give us your name. It's not getting back to the judge. We're using it to try to improve the process. And we get jurors to go to the site who have already served. I ask the judges to hand them a card when they leave the courthouse and are discharged that says, make your voice heard. It says basically, there's no compulsion, but if you don't mind sharing your views about what you went through, please go to the website and do it. And then we have a Twitter and Facebook presence, Jury Matters, hashtag Jury Matters, where we are getting people who are looking for how to get out of jury. So what we're going to do today now with our jurors who are here, let me get right into it. First, let me introduce, the judges that are here. And if you will stand up and so people, because what I tell people when I set up these lunches, and setting up 35 of them is like setting up 35 weddings or bar mitzvahs. It is very difficult. And we go to communities that you've never been in. If I didn't have someone like Judge Martinez and Judge Alvarez to get their colleagues to come to make the facility available, to give us, to encourage jurors to come. It would not take place. But so it's tremendously important that we get judges here so that the lawyers see how judges are interested in this subject. And get lawyers here so that judges see that lawyers are still thirsty and anxious to try jury cases and to learn how to try jury cases. So let me begin with our federal judges, Magistrate Judge Ann Burton. Can we turn on the lights now? Michael, can you get the lights back on? I'm not sure they really are. Slideshow's over. Great. District Judge Kathleen Cardone. Thank you, Judge, for coming. We have with us District Judge Martinez, and I'm going to ask him to say a few words to the group in a minute. District Judge Frank Montalvo. Judge, we have with us Magistrate Judge Leon Shaglower and Magistrate Judge from the Federal System, Mike Torres. Thank you very much for coming. And our state court judges are Judge Alvarez, who's sitting up here, and you'll hear from him in a second. Judge Linda Chu. And I understand that Judge Chu has appointed some kind of committee to deal with this problem recently. And I'd love to get you involved in helping us with this. It would be a great thing for you to work on. Judge Sergio Enriquez from the state bench. Judge Eduardo Gamboa. Judge Angie Juarez Baril. Judge Maria Salas Mendoza. Is she here?
I am sorry. I didn't want to stand.
Judge Selena Salas. We have even a former judge, Judge Tom Spisley, who is now a mediator here. There's the judge here, former judge, right? Correct. And I hope he would not tell the people. One of the reasons on the right, I'm glad mediators here. I'm glad former judges and mediators here. Because one of these judicial conferences, the judges told me, you know, a lot of mediators are out there telling the parties, you need to settle this case because you have no idea what a jury will do, which is just wrong. We do have good ideas about juries and what they will do. And in fact, all the studies that have been done show that about in excess of 80% of the judges agree. 80% of the cases we ask about, the judges agree with what the jury did. So it's not that we have a lot of mock trial exercises. So it's horrible when judges are there telling parties, you got to settle, you can't go try this case because you don't know what's going to happen. Two more judges. We have Judge David Briones, a senior district judge. Good. Hi, Judge. Welcome. And Judge Sue Carriga. Great. And let me talk about the church. Ms. Karalish served in a civil case in federal court. The trial lasted 3 days. A verdict was reached. Ms. Guido was in state court in a criminal case. It was a 2.5-day trial, and a verdict was reached. The next juror is Ms. Hinojosa. Annette, did I get it right? Okay. Hinojosa, right. Anyway, she was in so you were state or federal court? at court in a civil or criminal case?
Civil.
Civil case. And you served the trial was 2 days, and you deliberated a few hours in terms of your verdict. Mr. Sosa.
Yes, sir.
Yes, sir. You were in a case in state or federal?
Civil.
Federal. Federal civil case.
Yes, sir.
4-day trial, deliberations around 4 hours. And we'll ask for police. We have Mr. Valdez is not here. Mr. Darrell Marine, you were in a federal criminal case that lasted for 5 days and deliberation for 4.5 days, right?
Yes, sir.
One of the things that will be very interesting to you in this prison, a lot, is that not only is the number of trials, this is proved it, but the length of the trial is getting shorter and shorter. There are very few trials, civil trials in this country, less than 2 dozen, that last for more than 2 weeks around the country. It is a very small number. There used to be dozens and dozens. And there are law professors that have written about that and asked why that happens. So, Judge Martinez, would you just say a word of welcome to you?
Sure. Thank you very much for participating. We're delighted by this great turnout. One of the things that we wanted to do was to make sure that El Paso was included whenever we have opportunities to learn about programs that have been successful in larger jurisdictions like Dallas and Houston. And so all of you have made that happen, and I'm grateful to you. I'm grateful to my colleagues for participating. Mr. Sussman, this is a great legal community. We are primarily a criminal jurisdiction on the federal side. On the state side, you still try a good number of both civil and criminal cases. I want to thank those practitioners who almost practice exclusively on the criminal side. While a lot of the discussion today will pertain to jurors in civil cases, we know that the quality of jurors that we need is equally as important on the criminal side, if not more so, where life, liberty, and property is so often at stake. And I thought that hearing from jurors who have served in both criminal and civil cases would be immensely educational for all of us, civil or criminal lawyers. And I want to thank the jurors. Without the jurors, we couldn't have this program today. I'm immensely grateful to them for their participation. We are an audience that needs to be educated. Each of us has different purposes when we are either presiding over or engaged in a trial on one side or the other. And so we're here to hear from you as well. Thank you, Mr. Sussman.
Ms. Corrales, what did you like the least about your experience as a juror?
The least that I liked about the case that I was a jury in was that it took longer than it was supposed to. It was very repetitive on part of the attorneys. But that's the only thing, but other than that, yes, it took longer, but at the end, we did reach a verdict. But it took longer than what it was supposed to. Meaning, because of the case, what it was about, it could have been shorter.
In your trial, were you allowed to ask questions?
When we were deliberating, yes.
No, I mean during the trial
No,
itself.
sir.
So one of the things that all the studies show about this questions, allowing the jurors to ask questions, lawyers repeat themselves because we don't know what they're getting through. I mean, if that's something you were taught, you want to teach someone something, you just say it over and over again. If jurors are allowed to ask questions, you can figure out pretty quickly during a trial whether there's something that you overlooked, something that's bothering them, something that you have to emphasize again. And you don't have to repeat yourself as the way to get through to them. So that's one of the advantages of asking questions. Did you think that the trial was efficiently handled by the judge?
Oh, yes, it was. By the judge, yes.
Ms. Guido. Guido, Emma.
Guido.
Guido.
I answered.
Ms. Guido. What did you, what one thing, no short, because that was not a problem, it did not last too long.
We were sequestered for 4 days, so yeah, it's a
It
little.
did last, we were incredible, guy.
Yeah,
It did last too long.
4 days is a long time.
Did you understand why you were being sequestered? I mean, did that upset you?
Well, the case I was on was very high profile back when it was going on and for the previous 15 years. So my personal belief is that you said you did not know anything about the case, you were either lying or totally unaware of what was going on in your world. So I don't, while part of me understands why we're sequestered, the jury was an older mix, I think, of people who took the responsibility quite seriously. And I'm not sure that it would have been any different had we not been sequestered.
Okay.
I mean, because we all, well, with the exception of 2 people, we all had knowledge of the case.
All right. Listen, how about you? What did you like least about the experience?
I felt the negative aspect was we did have a police officer come in to give his testimony, and he was not prepared. Even though I understood the accident had happened a few years back, he had not read up. I just felt like we were all there being attentive, and we are affecting people's lives. That someone would have asked him to read over the police report to kind of bring him up to date. And so it was kind of a waste of our time because he contradicted himself throughout and really just had basically read the police report back. As jurors, we could have read.
Unprepared witnesses. Witnesses should have been better prepared. Mr. Thompson? Yes, sir. How would you improve?
Honestly, I'm one of those weird ones. I love jury duty.
Well, that's a fair question for me to ask all of you. Would you want to do it again?
Yes, I would.
Ever want to do it again?
Every day, if possible, less than
So, one of the problems we have with jury duty is people don't understand the unique privilege to be able to serve on a jury. And the some judges don't explain it well enough. I mean, it's always kind of the right problem. You will have to work with people from all different backgrounds, all different educational levels, all different political views and beliefs. I don't really know the languages. And you've got to, it does assume that there is a truth, and that 12 people or 8 people can figure out what the truth is. And those are things that in this day we live in, with fake news and no real truth, alternative truth, people taking sides and you travel. We don't have a lot of, I don't know any other thing a citizen can do that is basic to our democracy. Yeah, it's as basic as voting, because you are voting, actually. And the only problem is you all have to vote the same way. Yes, to return a verdict. So it's a little different. It's even more work. Is there anything we could do to improve?
As far as improvements, or I don't know how best, with so many challenges that you all have in front of you. All we need is the means, and I've been blessed that I do have the means. I could be in jury duty all year long if I want to. But as far as improving, sir, I think that your judicial system speaks for itself. I mean, you've done more than enough. And for me, it's grateful that I'm being asked to come and serve.
one of the things you mentioned was the sacrifices a juror made. Now, none of y'all had to sacrifice that much. I mean, it was not overly, no one served more than you.
I wouldn't mind it.
Yeah, I know, but some people do. Some people do, and some judges have a hard time getting jurors because they are excusing right and left for hardship. You know, they have a vacation pay.
We all have hardships. My wife has lupus.
Well, that's why people file cases like the file in El Paso, because people like to serve on juries. It's not quite that way, really.
Yes, sir.
And it's like, is there a problem? No, it's a commuting problem. I mean, you know, they're placing the country where people drive 2 and 3 hours a day to get to the courthouse to serve on juries, and then go home. So, yeah, one of the things that judges, did all of you on a regular schedule, like from 9 to 9, till 9 to 4? What was your schedule?
6 to 5.
6 in the morning?
Oh, you talk about work?
No, I'm sorry. About serving as a juror.
Oh, we have bankers hours. 9 o'clock. We love it.
I love it, bankers hours. One of the things people are doing, judging in the country, is they are holding their jury trials from 8 in the morning to 1:30. And they don't break for lunch. They ask people, they provide healthy snacks for them for about a 15-minute break, 2 15-minute breaks during the course of the testimony. There are no interruptions. People can go back to their businesses or their jobs, and every afternoon in the water, they miss the traffic if they go really getting before 8 o'clock. That's become very popular, particularly in large metropolitan areas where commuting is really horrible. So but it's not needed here.
Yes, sir.
Mr. Marine, how about you? What did you like least and what did you like most?
Well, as far as the least, I would say that the jury charge was, no offense, Judge Martinez, it was a work of art. But it was really long, really complicated, a lot of legalese, and I understand why we have to do that. But from a jury perspective, it was very, very unworkable, and I think it was so daunting that the temptation would be not to do it. So I thought that was probably the least favorable thing. I think it needs to be much simpler, much more straightforward, much more basic language, so juries are encouraged to read it. On the state side, we have that a little better. As far as the best thing, I thought very respectful of the jurors' time, very well organized, excellent security, and for a case, I think we had like 26 witnesses in our case. It moved along very efficiently, so everybody appreciated it.
Mr. Marine, the jury instruction area, which you pointed out, has been one that we have tried to focus on. Because what we have done is, and I've done it in one process, I go through a case, my case, an experience of our case, and sit there while the judge is reading to the jurors. We do not have a copy of it. It's not being shown to me. It's reading to them a charge for about an hour and 30 minutes, which no one can understand, including the lawyers who fought for days over what it would say. And so if I then go over my job to a general counsel, I'm not going to feel too good about my confidence in the jury getting it right and following the law. So what do we do in life where you read the instructions after you try to put the puzzle together? After you put the piece, you order over Amazon, you read the instructions first, then you try to figure out where things go, and you spread the parts out. We have urged judges, and some judges around the country probably need to do this, is give the instructions, all the instructions, right up front, not at the end. They get it up front, they put on a lavalier mic, they get off the bench, they wander much as I have, they talk to the jurors. The instructions appear on the screen. There's a PowerPoint, of the instructions so the jurors can see it. They prefer reading to listening. And each of them has their own copy, and they have a verdict form, they know the questions that they're going to be asked. And they have that at the beginning rather than at the end. And you will be surprised of the difficulties we have around the country persuading judges, not all, to do this, but when they do it, and they do experiment, the results are great. So let me ask this question of you all. When the lawyers, who was in federal court? Were the lawyers allowed to ask questions during jury selection? In your case, would the judge do it all?
We had a few minutes of attorney questioning, not much, but a few minutes.
We weren't allowed to ask anything other than
No,
what we
you weren't
got.
asking questions, but were the lawyers asking questions of you?
Yes,
They were allowed to ask questions.
yes.
State court, for sure. But so some federal judges are allowing the lawyers to ask questions. The typical thing that's happening around the country now is that the federal judges are giving the lawyers about 30 minutes each, limiting them. They used to go on for hours and hours. But do you know that there are jurisdictions in the country where the law prohibits giving the jurors written instructions? It has got to be done orally. New York is just a jurisdiction like that, state courts in New York. Almost everywhere else now, very common, everyone gets a copy of the instructions. So the harming and hogging, everyone can read it. That is something that could be improved after we did that. Did any of you, do you think the lawyers in your case were equal matched?
No, sir, they weren't.
They were not in your case. Well, I hate to ask this question.
What was the
Are the
question?
lawyers evenly matched? And the second question is, the better the lawyer wins.
Yes, he did.
Okay? That's good advertising for us. How about experts? Did you have experts in the interview? You did. Did both sides have an expert?
In my particular case, the defense did not call a witness because the prosecution called witnesses, and before the witnesses left the stand, they had somehow morphed into a defense witness.
And by the way, we have about 30 minutes left. I've got to say this earlier, but any of you in the audience, particularly the judges, who want to follow up, I don't have a right to hand you. Just stand up, please, and make it heard on the other side of the courtroom, so everyone can hear your question. If you want to ask a question, feel free to interrupt me, and particularly you, Judge Martinez and Judge Alvarez, if you have anything come to mind thus far? All right, well, when it does, please participate, because the program will be better. In jury selection, do you think, so that you know the situation, you know how it works, lawyers each get, I don't know what it's criminal case, but in civil cases, normally 3 challenges are given to each side, which means that they can strike a person for whatever reason. There's some prohibited reasons. You can't strike them because of their race or sex or something like that. But usually, the idea that this came about because, this is criticized a lot. All of the academics, almost all the academics, have criticized the availability of a perimeter challenge, which means a challenge where you don't have to give a reason. You just, if you're asked, it has to be a non-prohibited reason, which would be something about it. So, in the course of asking questions to you and exercise, do you think people served on your jury who probably should have served? Or did the lawyers and the judge, or effectively get rid of people who came in there with their, and don't tell us about the case you move on. Don't tell us about the judge. We don't know. Don't tell us about the warden. I have no names. But truthfully, you think, and I mean, that would not be reverse order anyway, if you just, the lawyers messed up and I asked you the question. But do you think there were people, was it an effective process? They didn't seem to weed out, were the people that eventually deliberated, do you think became with an open mind?
Yes, yes.
Yes, sir, I think they do.
My only thing is,
Ray, you are having a problem with that question. I'll cut it right back to you.
No, I'm good with it. I thought everybody had an open mind. I thought everybody worked very hard to try to do the right thing. I was immensely satisfied with it. I was a little surprised when one of those breakthrough challenges wasn't working on me, but nevertheless, we went forward, and I thought everybody had an open mind and did a great job.
my only thought is, every time I get a jury summons, I go. Every time my husband gets a jury summons, he goes. We have different views on what happens after we get there, because he can hardly wait to leave. I would like to think if I was waiting for 12 people to make a judgment on something that affected me, I would have people who were there not just because they didn't have anything better to do. So I feel it's an obligation and an honor to serve on the jury, and that's fine. And was almost everybody, when you were asking the questions about, do you have a person who's been in a car accident? Do you have a person who's been accused of a crime? Do you have a person who's related to somebody in the law enforcement? There were, of course, a lot of people that did, and those are not, on its face, I would assume, excusable actions. But we had 15 or 20 people every single question. And my only thought is, these people want off so bad, do you really want them on your jury? Because it was every time a question was asked, they had a problem with whatever it was. Whatever the question was. Do you have kids? Do you have to take care of them? Do you go to school? Do you work? Do you know somebody in law enforcement? Have you ever been a victim of a crime? Every single question. So my thought is, just cut these people loose. Cut them loose, and then let's get on with the rest of it.
Well, a lot of trial lawyers will agree with that. And judges, in most cases I've tried, when the judge has a close call, she or he will call us back in chambers and say, either they have some problem, some sickness, some problem. If they're trying to get out of there, and most of the times the lawyers, they don't have to exercise the privilege, because the lawyers agree on it. You were all warned by the judges during the trial not to do any internet research, not to go to social media, right?
I didn't have a choice.
Oh, they took it away. Yes, of course. And a lot of judges do that even in civil cases. You leave yourself alone. But you're not sequestered, so did anyone, do you think, I'm not asking you, do you think most jurors follow that instruction? Well, let me ask you this one. Did anyone bring into the jury room something, where the hell did they get that from? It was something that was said in court. They were coming in with extracurricular knowledge. Great.
I'll tell you, they most certainly did not follow the instructions. So, like some really important ones, like that we repeated like a number of times, like you really can't take into consideration the fact that the defendant didn't testify. Yeah, that's like an important one. So, no, some instructions were not followed, and I think that was partially because they're buried in a huge complex jury charge, even though it was stressed over and over again, but I can assure you their instructions are not followed. Ultimately, they were, but
The judges that seem to get the best result keeping jurors off the internet and social media are the ones who explain why we have this rule. And then explain it fully to the jury right up front. If you were in trial, you wouldn't want someone making a decision on a basis simply that you didn't even explore. No opportunity to explore the answers to it. And, people, my experience is that people, they understand why they do things the way they are done. They are much more cooperative and much more likely to do it. For example, another one one thing the judges say to you, and this is true in Texas, state court, it's not true. In state court, it's probably prohibited, if it is prohibited, for jurors to discuss the evidence before they deliberate. You're not supposed to talk to another juror about what you just heard. In federal court, most judges instruct the jury the same way, but there are other federal courts that allow them to discuss. In civil cases, but in civil cases, because the people who have done the study say, we learned here, people go to college, you can't go to a college class where you can't discuss with your fellow students what you just heard transpire. And so some people are suggesting we should make it possible for jurors to discuss with each other the last witness they heard. If they're all together in the jury room, that they can say, I didn't really let that person say, did you hear them say something? They didn't say what they were that night. Or did they mention something you didn't hear? Yes.
Is it possible as jurors to have, to take notes?
Yes. Did you take notes?
I did not, but
Were you told you could?
I don't recall, but I do think as you're sitting there, something does come to mind and you write, well, I'm very sure, I would lose a thought, but if I write it down and then I can go back to think about that, I do think allowing or giving a little tablet for the jurors to write.
Sussman, I did want to ask, you suggested that it might be beneficial if jurors could begin discussing the case as the trial progressed, right?
Yes.
And I guess, how many lawyers would like that? I can't imagine many lawyers would like for jurors to begin discussing the case as the evidence is being presented, whether you're on the plaintiff side or the prosecution side or the defense side. Are any lawyers in favor of that?
Well, I am a judge.
Depends on the case.
Judge, let me tell you what the instructions are. The instructions you give the jury is that you cannot deliberate and decide the case. No votes are taken. I do not want to go back to this because you explain that's the purpose of deliberation. And it's not fair to either side to make your mind before you go. But if after you are there, you didn't hear something the witness said, you're all together in the jury, or you didn't understand what the witness said, you could ask a clarifying question. Now, the way things should work, obviously, Judge, and I think and there have been studies on this, and the jurors who give those instructions tend to follow. The deliberations have been videotaped, certainly, with permission. And you can see what happens. So, but that's the argument. Usually comes from defense counsel.
I do think there are competing interests here. I mean, lawyers want to make sure the jurors hear what the evidence is, especially from the critical witnesses. So lawyers will want, and I as a lawyer wanted, to say things 17 times to make sure they got it. Jurors, as the recipients of that information, don't need to hear it 17 times. And heaven knows the judge doesn't need to hear it 17 times because we know what elements in a criminal case we just need evidence on. And in the civil case, we know exactly what the questions are that the jurors will be asked. Judges want to move cases efficiently because there are too many crowded dockets, both on the civil side and the criminal side. And jurors, I think, are mindful of the sacrifice they're making and want to be there for the shortest time possible and yet receive all the information necessary to be able to answer the questions at the end of the case. So with those competing interests, it becomes a little bit challenging to have an ideal situation in any trial.
I'd like to comment.
It is something I have.
Awesome. Yeah, comment on it. The question was, what do we do with jurors discussing the evidence during the case? Well, I can tell you from my experience, we had 26 witnesses over a week before the trial. We were not allowed to discuss the evidence. And had Judge Martinez not allowed us to take notes, it would have been a disaster. And so he allowed us to take notes. I took a lot of notes, and I think everybody, just about everybody in the jury took notes. But if you're not going to let them talk about the evidence at the end of 5 days and 26 witnesses, you've slept since then. And you forgot what they said. And so the juror note-taking was incredibly, incredibly helpful for our jury.
One of the things that a lot of courts are doing in longer cases, big cases like yours where there are a lot of witnesses, is they give the juror a notebook, a juror notebook with loosely paper that has a picture of each witness. And the line has line number, lines where the jurors can write what that witness said and they have a picture of all the witnesses. So you get, both sides have to agree that they will provide these programs. And you have to get them to agree that they will agree on what the person did. Executive Vice President in charge of marketing during a time period. And so virtually all the law organizations, all the trial organizations, American College of Trial Lawyers, AHA, have suggested for years that in complex cases, cases that will last a week, with a lot of witnesses, that jurors be given notebooks which have a cast of characters who people are going to testify, a chronology of events, sometimes a glossary of terms. There's a lot of times. One thing, I was just tried a case in July to a jury trial in July in San Francisco. It was a case involving an acronym. In the field that I didn't know what the acronyms were. All of the emails. You see a lot, y'all see a lot of documents in the cases you've been in, or not. How are they displayed? For anyone?
Well, kind of unusual. There were a lot of documents, but the bulk of it consisted of about 60 or 70 DHL packages that had been seized at the border. Inside of each one of those was about 8 to 10 tax returns. And so the jury took it upon themselves to examine each and every one of those. So down to our documents.
During the trial, how are documents displayed to the jury? The lawyer put them on screen.
They were on the screen and they were displayed effectively.
Excuse me.
They were displayed effectively. It was an effective presentation.
Was there one screen or just each juror in the box, or your screens in the box?
Yeah, we have, it's a rather modern building you're in, and so there are a number of screens throughout the jury. The other advantage that we have is we have a computerized system that affords the jurors in the deliberation room the opportunity to review documents or other admitted exhibits on a visual screen, and you can control it. That way you don't have to be looking over your shoulder and looking at a single document.
Did you have that, Mr. Simpson?
Yes, sir, we did. I was amazed because that was the first jury that I had been able to read a TV monitor in front of us where they had documents on the screen and all of a sudden it would pop up in front of us and we made it a lot easier for us.
Yes, but one thing that is one of the things that's been suggested is it used to be, when we first began jury trials in this country, the juries decided the law as well as the facts. I mean, basically, that's what they did. And there were people that didn't like that. and thought that the job of deciding the law should be judged by the people who are trained. And then we had this whole thing about instructions, about you, the jury, decides facts. The law tells you, the judge tells you how to decide those facts and gives you the law. Over time, there's been judges, I think, and I don't mean to be disrespectful to you judges, but they have, in it's a long period of 200 years, have tended to take power away from jurors. And it happens, including the ability to set aside jury verdicts, to give new trials. Judges are, and so one wonders, is one of the reasons people are trying fewer cases today is that they have less confidence in the jury's ability to get it right, because the jury is not given the same tools that a judge alone or a group of judges with an arbitration panel would have to make a decision. And, I don't know that's, so the point is, we're trying to give juries more tools to do a better job. And the people whose fates are decided think it was not because the jury messed up. And one of the things that we are doing a research project on right now is testing the proposition that people who lose civil cases are much more likely to accept an adverse jury than they are an adverse decision by a judge in a bench trial. If the judge rules against them, and if the judge is crooked or stupid or biased or whatever they say, if a jury of 12 rules against them, this is the proposition we're trying to test. We think that people who lose are more, they blame their lawyers for not being able to explain to the jury, not effectively communicating to the jury what the issues were. But it's usually not because someone was crooked or stupid or anything like that. It's a con. So, and one of the reasons we try to do this is we want people to have confidence in juries and jury voting. One of the worst thing that happened to the trials in this country was the hot coffee case, which the Business Roundtable made a huge deal of with a woman who was holding a cup of coffee and dividing between her legs and over on the coffee spill, with 33 burns over her legs. And the jury gave her a big verdict, and it was people who were not in the trial, not with the evidence, used that as a poster trial to criticize jury trial. Juries don't, they runaway verdicts, runaway juries, and they give too much money. And the recent studies are now showing that we have been able to tell that if you want money as a plaintiff, you're likely to get more money from the judge than from the jury. So it's been fairly effective. That's Judge Alvarez, is that with you?
Yes, that's true.
What's your explanation?
Well, automobile accident cases here in Paso, for instance, juries don't get much money. That's just the way it is. And they probably get more money from me than they would from the jury. That's the way it is.
But it didn't, it was not always, it's changed. And I think it's changed because cases like the Donald case have been used to criticize juries and they come. One of the questions that the lawyer frequently asks people during jury selection is, do you think every lawsuit is frivolous? Have you heard, do you think every lawsuit is frivolous?
I do think that you do need to educate the jury when they're looking at deliberating for certain dollar amounts. Mine was a very simple civil case, but at the end when the attorney asked for a certain dollar amount, we could not understand how he even came up with that. So I think if El Paso jurors are maybe not awarding that much, maybe it's an education that needs to happen. It may be education to the jurors on the dollar amount and how they got to the proposed number.
After the trial was over, your trials were over, did you try to find out you're free then? First, you're free to talk to the lawyer. Were any of you contacted by lawyers and wanted to talk to you? You were. And were you talked to them? Did you talk to them? That's nice. And did you understand, you did not object to that? Good. Were you contacted by both sides or just one side? Okay. Ms. Corrales, how about you? Were you talking to them about the lawyers in the case?
They did come after the case was over, so we could meet with them.
In the courtroom or the hall, jury room?
Finished deliberating, because we wanted to meet with them too. But only one side came up.
The winner?
The winning side.
The winning side. So,
And with the witnesses there too.
right. The witnesses came to. So did any of you go on the internet and to find out questions you did not know the answer to? Like what happened? Did the guy really go to jail? Did he really get money? Were any of you curious of finding out more about it? You didn't know. Does anyone here have any questions? Excuse me. Yes.
When the trial was over, everybody came in, the judge, all of the attorneys, both the prosecutors and the defense. I was only contacted outside of that setting by the defense attorneys. But all of them came in afterwards, and they pretty much sat there as long as, because we had a lot of questions, they sat there as long as we wanted, and they answered all of our questions. And it was very helpful.
Okay, Judge, we are at the stopping point. Are there any other questions in the audience you want to ask the jurors for the next minute or two? Let me thank them all for coming in. It was great. And thank you all for being here today. I do have a couple of favors to ask of you, lawyers and judges. First, please respond to the questionnaire this afternoon about whether this should be done again. And please, if you're willing to help set it up, the next one, and what we'll be talking about, that we were to. The best program, and we've not been able to get a program like this yet, which I'm looking for, is a trial that goes on for a couple of weeks, a big trial, an important trial. That after the verdict is returned, it's set, case gets set. And then people are free, including the judge, to talk about what went on with the lawyers that participated and all the jurors on the same trial. And you get then a very interesting, that would be worth, I've had some fun to attend, to see that. But you've got to find the right case. You've got to be alerted about the lawyers or judges who see that in their courtrooms, see it in this community. Let us know if we put our program quickly. Thank you, Judge Martinez and Judge Alvarez for coming. And thank you, jurors. And if any of you are willing to stay, Michael, raise your hand, would love to talk to you for a few minutes about your experience.
Thank you all for showing up today. We appreciate it. I want to thank my chambers and Everett Gonzalez and Laura Gonzalez for helping set everything up, our IT department for making the microphones as useful as possible, and please be safe. Thank you very much.